Okay, imagine this. You've poured everything into your invention, you file the patent application, and then bam, you get a decision back from the USPTO and you just fundamentally disagree. What happens next? What are your options?
That's a really common feeling, actually, getting that rejection, feeling that roadblock. And that's exactly what the appeal system is there for.
Right. And that leads us straight into our series Unpacking the Manual of Patent Examining Procedure, the MPEP. We're diving into your source materials, these, well, pretty dense MPEP sections to pull out the key insights.
Exactly. And today, we're starting right at the beginning of appeals in Chapter 1200. Specifically, Section 1201, the introduction.
Think of this as your tailored guide. We're digging into MPP 1201 for you, getting right to the core principles so you can quickly understand what appealing a USPTO decision actually involves.
So let's start there. What is an appeal in the patent world? Fundamentally, it's the formal process for you, the applicant, to challenge decisions that go to the substance of your invention's patentability, the merits.
The merits. So things like, is it new? Is it non-obvious? Is it even the kind of thing you can patent? The core reasons why they might reject your claims, often based on prior art.
Precisely. It's when you disagree with the examiner's final conclusion on whether your claims deserve a patent. And you have a legal right to do this. It's authorized under U.S. Law 35 U.S.C. Section 34 gives applicants this path.
Okay.
And it's interesting, the MPP actually mentions the older pre-AIA version of that law, too. It talked about appealing after being twice rejected. Gives you a little bit of the history.
Okay, so you're challenging a substantive rejection. Who hears this challenge? Who makes the call?
These merits-based appeals, they go to a specific body within the USPTO. It's an administrative court called the Patent Trial and Appeal Board, the PTAB.
PTT, yeah, that name comes up a lot. And the NPP mentions it used to be called something else, Board of Patent Appeals and Interferences.
That's right. Same basic job, just a different name historically. Now, a really crucial point for you to grasp is when this chapter 1200, actually applies. There are specific dates involved.
And these aren't just minor details, right? This determines which set of rules you're playing by.
Absolutely critical. The procedures we're talking about today primarily apply if your notice of appeal was filed on or after January 23, 2012.
Okay.
And they also apply to certain proceedings that started after September 16, 2012.
Right, and those dates tie back to the America Invents Act, the AIA. That was that huge overhaul of U.S. patent law. So if your appeal process started before those dates, you'd be looking at a different set of MPP rules, essentially.
Exactly. Which brings us to maybe the most important distinction laid out in MP 1201. And honestly, it's something that trips up a lot of applicants. The difference between matters you appeal versus matters you need to petition.
Okay, so we appeal a rejection on the merits, the substance to the PTAB. What kind of things fall under petition?
Petitions are generally for procedural issues. Think disagreements about how the examination was conducted. The MPP gives examples like maybe you disagree with a restriction requirement.
Where they make you split your application.
Yeah, exactly. Or maybe the examiner refused to enter an amendment you submitted. Those kinds of procedural objections or requests typically go to the director via petition, not to the board via appeal.
Okay, so simplifying may be too much. Appeal is about the invention's patentability. Petition is about the process of examination.
That's the core idea, yes. But, like most things in patent law, there's a key nuance here. The MPP points out that sometimes a procedural issue can actually be the reason for the rejection. It effectively determines the outcome on the merits.
So the way the examiner handled a procedure directly led to them saying no to your claims.
Precisely. And in those specific situations, even though it started as a procedural thing, it can become appealable because it's dictating the substantive outcome. The MPP actually cites an old case in Re-Hanjold.
Hanjold, okay.
Yeah, it's a key case that helped clarify this. It showed situations where a procedural ruling essentially blocked the applicant from even making their case on the merits. So that procedural block became tangled up with the rejection itself.
I see. So the PTA doesn't just take the examiner's label objection or rejection at face value. They look at the actual impact on your ability to argue for your patent.
That's the idea. If a procedural ruling stops you from getting a fair shot at arguing patentability, challenging that ruling might actually belong in your appeal to the board, tied to the rejection it caused.
This distinction, appeal versus petition, it's also linked pretty tightly to timing, isn't it?
Very much so. The rules for petitions, like in 37 CFR 1.181F or 1.144, they have really strict deadlines, usually much shorter than the appeal timelines.
And what happens if you miss that short petition deadline?
Well, the practical result is if you have a procedural issue you need to petition about, you generally have to do it right away during prosecution. By the time you actually get to filing an appeal brief, those petitionable issues are often, well, moot.
Meaning the deadline passed ages ago.
Exactly. The window closed. You typically can't bring it up for the first time before the PTP if you didn't petition the director when you were supposed to. The MPP also mentions other things usually handled by petition, like challenging if the office says your application is abandoned, or arguing about whether an office action was properly made final.
So figuring out early on, is this appealable or petitionable? And then acting fast on petitions, that's really key.
Absolutely vital. Use the right tool at the right time.
Now, we've been talking about challenging the examiner. Just to be clear, this chapter, 1200, is focused on one specific kind of appeal, correct?
Yes, that's right. The MPP makes it clear. This chapter is about ex parte appeals.
And ex parte means?
It means it's just between the applicant, so you and the office, represented by the examiner initially, and then the PTA on appeal. There isn't another opposing party involved, like a challenger.
So this doesn't cover appeals in things like, say, inter partes review or other post-grant proceedings.
Correct. Appeals in those situations, like inter partes reexaminations, have their own set of rules. You'd find those in different parts of the regulations, like 37 CFR 41.60 through 41.81, and they're covered elsewhere in the MPP. Chapter 1200 is your roadmap for appealing an examiner's rejection during the initial application process.
Got it. Now, one thing mentioned in this introduction, Section 1201, that seems really practical is the PTAB Pro Bono Program.
Yes, that's a really valuable resource to know about. The MPP highlights it specifically. It's designed to help inventors who might not have the financial resources for the appeal process.
How does it work? What kind of help do they offer?
If you're eligible, you can get free legal help from volunteer patent attorneys or agents. They'll assist you specifically with preparing your ex parte appeal brief to submit to the PTP.
Wow, that sounds like a pretty significant way to try and level the playing field, especially given all the complexity we've just been talking about. Access to justice, really.
It absolutely is. It's an acknowledgement that, look, preparing a good appeal brief is hard work, it takes expertise, and this program provides a path for inventors who might otherwise be shut out due to cost. You can find information on eligibility and how to apply on the USPTO's website on the PTAB Pro Bono Program page.
Good to know. Okay, before we wrap up our look at MPP 1201, we need to make sure we include the acknowledgments and the disclaimer that were part of our source material.
Right, yes. First, we would like to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series.
And the disclaimer.
Disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.
Okay, so let's distill this down. Looking back at MPP 1201, this introduction to appeals, what are the absolute must-knows for you, the listener?
I'd say the big ones are knowing appeals are for challenging those substantive rejections before the PTAB. Understanding those key AIA cutoff dates, January 2012, September 2012, that determine the rules, and really getting your head around that crucial, sometimes tricky difference between appealable merits issues and petitionable procedural ones.
And remembering that Henschel principle is part of that, how a procedure can sometimes become appealable if it's the basis for the rejection.
Exactly. That's a key nuance.
Plus, understanding the strict, often really short deadlines for petitions compared to appeals. That dictates your strategy. And of course, knowing that resources like the PTAB Pro Bono Program exist is important practical information.
Right. And maybe a final thought building on that.
Yeah.
Considering how complex these distinctions are, how vital timely action is, and the fact that there's even a need for a program offering free legal aid for appeals.
Yeah.
What does that tell you about how easy or maybe how difficult it is for individual inventors to really navigate this system effectively on their own? It's something to ponder.
Definitely food for thought. Well, we've laid the groundwork now with this introduction in 1201. The MPEP naturally moves on to the specifics, how you actually start an appeal, the briefing process, all of that. We'll keep digging into Chapter 1200 in our next deep dive. Stay tuned.